Miriam, should I finish by 12:05 or 12:10?
Well, let's see. We'll see once we're done with my quick housekeeping and the introduction, and then
Okay, you
uh,
let me know.
yeah, I'll let you know. Yeah, I'll send you a direct message.
Okay.
Good morning.
Good morning.
How
How are
are you?
you?
I'm
I'm
fine.
so excited.
Me too.
Me too.
Yes.
This is this is going to be a great hour.
Yeah, it is. It is. And I see we're still getting our attendees coming in.
Oh,
Um,
quite a number.
we
136 already.
well, our IT department told us that 377 registered as of this morning.
Wow.
Almost 400.
I am humbled.
Yeah, physically, that would be really hard to accommodate in the court building.
Yeah, that would
Would have
be
to,
the
that would be
marshal would come.
hard. I know. Like, no, no, too many people.
We will have to do that outside.
We
Ah, that would be good.
On
I'd be
Bourbon Street.
with the
would do it outside. Gives me some ideas.
Miriam, check the Q&A.
All right. Yes. Okay. Got it. All right. Okay, we have a greetings to Mariano from Fabio Descalzi.
Yeah, he's a friend from Uruguay.
Okay, cool.
Hi, Fabio. Thanks for being there.
Well, all right, it is 11 o'clock, so I think we're going to get started. I'm going to start off with some very quick housekeeping. I think you are all on mute. And if you have questions, go ahead and enter them into the question and answer box. We're going to hold all questions until the end after Mariano's presentation, but go ahead and enter them in and we'll try to get to as many as we can. Also, since this is for CLE credit, I'm going to break in during the presentation and give 2 passcode words. At the end of this webinar will be a poll. If you want CLE credit, then you'll need to answer the poll with your name and your borrow number, plus the 2 passcode words. That information will then be passed on to MCLE to ensure that you get your CLE credit. If you don't want CLE credit, you don't have to worry about that. Only if you need CLE credit. So I just wanted to let you know that's how we take care of that. I think that's really it for me. And so I think I'm going to now turn it over to Professor Olivier Morito to introduce our speaker, Mariano Vitetta. Thank you everyone for joining. And now I'm going to jump off and I'll jump back on in a little while.
Good morning. I am Olivier Morito, Professor of Law and holder of the Russell Long Chair of Excellence at the Louisiana State University Law Center, where I serve as the Director of the Center of Civil Law Studies. It is my privilege this morning to introduce Mariano Vitetta, who is presently the Research Associate at the Center of Civil Law Studies. Mariano comes from Argentina. He studied law at the University of Buenos Aires, where he got his law degree. And he's also a certified legal translator. And he has a rich teaching experience already because he's an assistant professor of legal writing and research at the Catholic University of Buenos Aires. He's a professor of legal translation in Argentina, and he serves also as an assistant professor of teaching the introduction to the common law for civil law students there in Argentina. And he also is active as a freelance translator in Argentina. He is a well-published author because he is more than 10 articles published or forthcoming, and some of them in the Journal of Civil Law Studies at LSU. And he has published numerous legal translations of well-known articles or legal material. And how is it that Mariano Vitetta is now in Louisiana? Well, here is the story. A few years ago, he contacted me saying that he was interested in our LLM program in comparative law, but mentioning the fact that he is a professional legal translator. As the CCLS has a big legal translation program, I thought, this is marvelous. Of course, his credentials were phenomenal. He was admitted in the LLM with full scholarship and did extremely well, though with COVID along the way. But Mariano came here with his family, with his dear wife, Natalia, and their son, Santiago. I'm not sure that Santiago is listening this morning, still a little bit young. And Mariano accepted to serve as the research associate at the Center of Civil Law Studies in these difficult times, and is doing amazingly well. The only reason, there are two reasons, however, why I do not have him or force him to stay in Louisiana. Well, the first one is that slavery has been abolished, indentured work, etc. I don't want to hear we commemorate the bicentennial of the death of Napoleon, and everyone in France say Napoleon reestablished slavery in the French colonies, and it's sort of mixed commemoration. So no, I'm not going to force him as a free man. But the second reason is that LSU does not offer a doctoral program in law. And the only thing missing, but I know it's not going to miss for very long, is that Mariano, of course, aspires at having a doctorate in law, and for that reason wishes to come back to Argentina, though he has a very interesting international project to earn a doctorate both from Argentina and a prestigious university in the Netherlands, the University of Maastricht, where, by the way, a couple of former research associates at the Center of Civil Law Studies are presently law professors. So this is a position that goes then a long way, but I'm speaking too much. And without further ado, I ask you to warmly welcome our speaker today, Mariano Vitetta. We would be in the room. I would please ask you a big round of applause. Thank you for your attention. And here is Mariano Vitetta.
Wow, Professor, what a presentation. Thank you very much. I will try to share my screen now. Let me see. Can you see my screen, my PowerPoint? Great, thank you very much. I want to start by thanking Miriam Charles at the Supreme Court of Louisiana Law Library for putting together this event. And I have an immense debt of gratitude to Professor Olivier Moreto, Director of the Center of Civil Law Studies, who is the mastermind behind not only this webinar, but the whole translation project as a whole. Without Professor Moreto, there would be no Spanish translation of the Louisiana Civil Code. So again, Professor Moreto, thank you very much for your continued support and your trust. It's a privilege for me to be working close to you here in Louisiana, and I think our continued work will continue for for years to come. So I've decided
Mariano, real quick, we're going to go till noon, okay?
Okay, excellent.
Okay, thank you
very much.
All right.
So I've decided to use the word jurilinguistic in the title of this presentation. I'm saying that translating the Louisiana Civil Code into Spanish is a jurilinguistic exercise because I'm using the terminology coined by Professor Jean-Claude Chemard in Canada. And I think that term reflects very well what is required to translate the Louisiana Civil Code with what it's needed for an audience to use it and for the translation to be useful at large. So jurilinguistics in Canada indicate a combined experience in law and language. And I think this translation requires knowledge and expertise in legal translation, comparative law, and legal history. And as you will see, we are combining all of these characteristics or features in our project with the many people we have participating in it. So a little bit of the structure of my presentation. This is how we are going to deal with this presentation today. I want to introduce the project to you. We are going to say a few words about the structure of the project within the Center of Civil Law Studies at LSU. We're going to talk about some of the legal history underlying the whole translation experience here in Louisiana. We are going to say some words about the eclectic style of the Louisiana Civil Code, which is very interesting. And we are also going to discuss the underlying translation theory, how we are approaching this translation from a theoretical point of view. And then at the end, the fifth part of this presentation will be how we are applying all the abstract and theoretical things I've been discussing before in specific translation examples. And I think this is what you need to see to realize the work we are doing. Okay, so a few words about the project. We are going to see why we are translating the Louisiana Civil Code. We are going to discuss the translation team, how this process of translation is going on, and what sources we are using to translate this code. So why translate the Louisiana Civil Code? Well, this is a project, as Professor Morto said, of the Center of Civil Law Studies, directed by him. And by the way, Professor Morto has an article that is upcoming about the trend of legal translation in Louisiana. And he has a claim which can be validated in reality, I think, that Louisiana's legal system is based on translation. Of course, you know that translation in 200 years ago was from French and Spanish into English. But now the tide is changing and Louisiana is starting to translate its legal materials into other languages. You can see here in one of the sections of the Center of Civil Law Studies website that the translation project headed by Professor Morto started with the French translation. That this was the translation of the Civil Code of Louisiana in force into English, into French, I'm sorry, from English into French. And this translation that we've been doing into Spanish is part of the same project. It's not a separate project, and we will see what the consequences or the results are of this connection between the two projects. So first of all, when we started planning the translation into Spanish, we were thinking about who is going to read this translation and what is our main intended audience. So in line with this trend of trying to export Louisiana law to other countries and to make it available for people outside Louisiana, we thought that the main readers of this translation would be academics and lawmakers in Spanish-speaking countries who do not master English or who have a poor command of English. So if they have these materials in English, in Spanish, they will, we think they will have a more easy access to the ideas underlying the Louisiana Civil Code, and maybe that will inspire law reform in their countries. And also, we are thinking of Louisiana residents who speak Spanish, of course. Civil codes, as we know, do not only speak to the experts, they also speak, especially modern civil codes from the Code Napoleon to this day, are supposed to speak to the citizens in a wide sense. I'm talking about members of a society. And we will see the relevance of this consideration in relation to the fact that Spanish is an increasingly important language here in the United States. So while we were starting with the project, was our starting point. These were the two audiences we had in mind at the beginning, but as soon as we started publishing extracts of the translation, we started receiving some comments from unintended addressees, but which are very welcome. Of course, we were not thinking of them at the beginning, but we realized immediately that this was going to be useful for them. For example, Louisiana court interpreters and translators. Spanish is increasingly an important language in the United States, and Louisiana is no exception to that. And some court interpreters and translators told us that this was a useful tool for them. So we are very happy about that. And also Spanish-speaking lawyers preparing for the Louisiana bar. You know that in the United States, it's very common for foreign lawyers to come here, get an LLM, and try to pass the bar. In the case of Louisiana, if they have their materials in Spanish, that could also help them prepare for the Louisiana bar, even if they have to master the immigration course by force. But there's another reason why translating the Louisiana Civil Code into Spanish is relevant, and this has to do with history. Louisiana, as you know, was once a Spanish territory, and we believe that having a Spanish translation of this code would close the circle. The Louisiana Civil Code was originally drafted in French. It was then translated into English, then into French again by Professor Moreto. And we think that having a Spanish version of the Louisiana Civil Code will make justice to the history of this state in which Spanish laws and French laws were once applied. So one of the problems we have when we translate into Spanish is that Spanish is a very widely spoken language all over the world. And it's not that one country has the main Spanish-speaking population in the world, and you cannot just choose that Spanish and go for it. You can see here some of the countries which have Spanish as their official language. So one of the challenges of this project is, who are we talking to? Who are we writing for? We want, of course, people from all these countries to understand, but there are differences. And even if all these countries that appear on the screen are civil law countries, there are differences in the Spanish spoken and written in each of these countries. It is true, though, that there is, we could say, a core element of formal legal Spanish that is understood among all the countries. But we want to try, we're striving to be as international as we can. And as some people say, we're trying to use neutral Spanish, though that is an invention, because neutral Spanish is not something that is spoken or used in any single jurisdiction. But neutral Spanish is the idea that we are going through the middle path and choosing terms or expressions that are widely understood in all the countries. So some quick facts about Spanish. Of course, it's a very important language all over the world. There are almost 500 million native speakers in the world. More than 500 million people are fluent in Spanish. And it's the third most used language after English and Mandarin Chinese. And as we know, the use of Spanish is increasing in America with the continued immigration flow we have from Spanish-speaking countries. So estimations say that by 2060, the USA will be the second Spanish-speaking country, only second to Mexico. So we believe that a Spanish translation, of course, is warranted in this case. There is support to convey the language of the civil law in Louisiana in Spanish. You have some numbers here of the main Spanish-speaking countries by population. You have Mexico, Colombia, Spain, Argentina, and Peru. Of course, one of the problems or challenges is that I am from Argentina, and as I am the person in charge of doing the first draft of the translation, my legal language is from Argentina. Even if I know language from other countries, I do not know the legal language of every specific jurisdiction in the world that has Spanish as an official language. So that's why we try to have as many readers from all over the world who can take a look and read our translation and say, hey, this is not understood in Chile, or this is not understood in Costa Rica or in El Salvador. We would love to hear back from readers all over the world who can tell us if the work we are doing is understandable to them. So the translation team that's taking this project forward is, of course, headed by Professor Olivier Molertor, who is as he said, the director of the Center of Civil Law Studies, within whose structure the project is operated. I am the main translator, and Maria Natalia Rosonico, who happens to be my partner in business and in life, is the assistant translator and reviser. We will see in the upcoming slide the workflow process we are following. And she is revising the text after I translate it and before we revise that with the director and herself. So, and then we have a validation committee. This is something that if you take a look at the French translation project, you will see that the structure is very similar. And the idea of having a validation committee is copied or taken from that French project. And the idea is to have experts in legal translation and in civil law who can read the translation and tell us whether we are doing a good job or not, if they are understanding what should be understood in these cases. And we are also using them to make questions. We are not only giving them the translation once it's done, we are also using them to make questions before we translate. And you will see examples of that when we arrive at the part of the discussing examples. So we have Jimena Andino Dorato from Montreal, Canada. She's a jurilinguist. She's been doing a lot of studies on the translation into Spanish of the Quebec Civil Code, which is a model for us, as you will see further down the road. We have Francisco Alterini and Ignacio Alterini, who happen to be brothers. They are both from Buenos Aires, Argentina, and they are experts in real rights and obligations, a very important area of the civil law. We have Ricardo Chiesa, who is a legal translator and professor of legal translator in Buenos Aires. He's helping us a lot with choosing translation strategies and specific questions about how to approach this translation. We also have Alejandro Garro, who is probably the first, to my knowledge, the first Argentine who graduated from LSU with an LLM degree and who is now teaching at Columbia. And though his main focus is now international arbitration, he's done a lot of studies on the Civil Code of Louisiana, and he even participated in some of the law reform efforts in this state. Then we also have Aniceto Masferrer, who is from Valencia, Spain. He is an expert in legal history, and he, as being from Spain, we are expecting from him and others from other countries to tell us whether things can be understood naturally and easily in Spain. We also have Luis Muniz Argüelles, who is probably the top scholar in the civil law in Puerto Rico. He's written a lot about language and law in the context of Puerto Rico, and he helps us a lot with Puerto Rico terminology when that is useful for our translation. We also have Agustin Parise, who's been my predecessor in this position and is now working as a professor in Maastricht University in the Netherlands. He's an expert in legal history and the process of codification, so he's been helping us a lot, not only reading the translation, but also identifying the sources that we could use from a historical perspective to tackle this translation. We have Julio Cesar Rivera from Buenos Aires, an expert in the civil law, mainly in contracts and in what in Argentina we call the general part of the civil law, who was in charge of translating the Civil Code of Quebec into Spanish. So his experience is extremely important for us. We have Andrés Sánchez Herrero, who is an expert in contracts and in civil law from Rosario, Argentina, who is helping us with the part we are now revising on contracts. And we also have Lesia Vicente, who is an expert in civil law, who is a Portuguese native speaker, and one day maybe she will tackle the translation of the civil code into Portuguese. So to have an idea of what we are doing, what's the translation process behind this project? The first step is having a draft of the translation. That's what I do in step 1. Then it goes to the reviser. That's step 2. And then the third step is holding weekly meetings with me, the reviser, and the director to analyze every sentence, every word in the translation to see whether what we are saying in Spanish conveys the meaning correctly. A byproduct of this project, which is extremely tied to the French translation, is that we are contrasting with the French all the time, and this translation is helping to improve the French. And this is something very natural, you know, translation is an ongoing effort, and you finish when you have to finish, but there's always room for improvement. And I wish when we finish with this translation to have the opportunity to go over my translation again a couple of years from now, because I'm sure I will find things to improve. And we are having this opportunity now to improve the French, and I think it's a very good opportunity. And step 4, the third revision, is the validation committee. Even if, as I said, we are involving them before, because we are sending them questions or extracts for them to give us an opinion before we finish with the translation. So the first step, for those of you who are not translators, this is what we are doing. The first step. This is how we translate, or how I am translating. I am using a translation tool called Trados. The good thing about this translation tool is that it's very convenient for you to take a look at the original text and the target text in columns. And so one of the benefits of using this system is that we are creating a database of terminology, what we call in translation, a translation memory. So everything we are translating is kept in a memory. So for example, whenever there's an article that has a structure that's repeated further down the road, we can pull that from the translation memory and follow the same style, so that two articles that look the same are not translated differently. This is extremely, extremely useful. And I have to say that working with this tool is great for the third step in the process, because when we are having these weekly meetings with Professor Moreto and Natalia Resonico, I am sharing my screen and they see what I'm doing, and I can make amendments and corrections to the translation on the spot. And that goes directly to the translation memory. And in a way, I like to say that this translation is a creature of the pandemic. I started this translation by the end of May last year, right in the middle of the pandemic. And so there was no possibility for the three of us to be together in the same room. Had it not been for the pandemic, I think we would have followed that path of being in the same room, watching all the same screen and doing changes that way. But with the pandemic, we had to use Zoom right from the beginning. So I think that's a great benefit of this project. Here you can see the first meeting with the validation committee. This was when the project was in the very early steps. We wanted to discuss with Agustin Parise and Ricardo Chiesa the guidelines to start with this project. With Agustin, we were concerned to discuss with which sources could be useful to translate the Louisiana Civil Code, because there are some old translations into Spanish of the old Louisiana Civil Codes, and with Ricardo Chiesa, we wanted to discuss how to approach this from a legal translation point of view in general, from the point of view of theory, who we were approaching, what strategies we could use, how to deal with the problem of legal Spanish and differences among jurisdictions. So within the translation process, the publication we are planning to follow, or that we are following, has three parts. First of all, we are publishing extras in the Journal of Civil Law Studies. This journal is one of the publications, or the flagship publication of the Center of Civil Law Studies, headed by Professor Olivier Moreto. And he did the same with the French. He was publishing extracts of the French translation. Then we have the Louisiana Civil Code online website, where you can see, you can access for free all the translations. And in the future, we are planning to go in print with a trilingual translation, as I will show you in a couple of minutes. So this is how the translation looks like in the Journal of Civil Law Studies. In 2 columns, you have to the left the English and to the right the Spanish. This is the Louisiana Civil Code online website, in which you already have the English, French, and Spanish buttons at the top. You can touch any of those buttons and it will take you to the part of the code you want to read, and you will have either the French or the Spanish version as you choose. This is how it looks like. Above you have English and below the Spanish. So when we are thinking about the print publication of this translation, we are thinking of this. Our model is the Civil Code of Quebec, which is trilingual. Of course, in Quebec, the situation is different from Louisiana because the French and the English are official translations and they're stand on an equal footing. And that's not the situation in Louisiana, in which only the English is the official language of the Civil Code. So, but anyway, we want to follow this structure. Miriam, you want to join in?
I'm going to provide the first code word. That word is lemony. The first code word is lemony. Thank you.
Thank you very much, Miriam. So the progress made so far can be seen in this chart. You can see that we already have a first draft of the entire code. The Louisiana Civil Code is divided into 4 books. We already have a first draft of everything. We are working, and we have already published the whole book 1 and book 4 in both the Journal of Civil Law Studies and the Louisiana Civil Code online website. We are now working with book 2 that is about to go to the validation committee, and it will be published by September or October this year in the Journal of Civil Law Studies. And we are working hard on book 3. If you know something about the Louisiana Civil Code, you know that book 3 is the name of the game. Most of the points are there. That's the longest part of the Civil Code. So this project is not happening in a vacuum. I am not the first to translate the Louisiana Civil Code into another language. As you know, to the right, you can see the translation made or headed by Professor Morito. And to the left, you have to see, you have to know also that there's the translation made at Loyola by Professor Markus Puder into German. And this is extremely important. Even if the command we have of German in our translation team is kind of limited, we resort to both the French and German translations for translation strategies, how they approach a certain problem we stumble upon. So this is extremely important, and I really believe that the Spanish translation is happening as a result of standing on the shoulders of giants, because these 2 translations are excellent works which have already been published. I think one in 2016 and the other in 2017. Other important sources from a historical point of view are these works known as concordances. After the Code Napoleon was spread to other jurisdictions, it was common for legal authors to compile concordances in which you could see several codes in a column format, so that you could compare the same provisions in different codes. So we are paying attention to this is Berlanga Huertas, the translator who did this. It might be the first translation into Spanish of the Louisiana Civil Code. And even if this is a bit updated, it might guide us, might provide us some guidance on how to approach our translation. So that is as far as the project itself. And now we need to know something about the legal history of Louisiana to understand how we are tackling this project. There are 3 years or 3 dates you have to have in mind to understand the Louisiana Civil Code. Those years are 1808, when the digest of the civil laws now in force in the territory of Orleans was published. The digest, also known as the first Civil Code in Louisiana, which was drafted in French and translated into English. Professor Bernard Palmer at Tulane has just published a book on the lost translators of this digest, whose identities were not known until he discovered them and published that in print. So that's, I sincerely recommend that you read that book because it's excellent. So after 1808, there were many complaints about the functioning and the structure of the code. So recodification efforts were tackled in 1825. And then we have a new civil code in Louisiana, this time called Civil Code, straightforwardly, which was also written in French and translated into English. So both in 1808 and in 1825, we have bilingual civil codes, originally written in French and translated into English. The interesting thing about this is that both versions, both in English and in French, were supposed to be on an equal footing. They were both valid authoritative texts. The reality is that the courts found, because the practitioners found that the translation into English was very defective, and as a result of jurisprudence, a rule was created that the French took preeminence over the English in cases of in case of discrepancies, and this is informing our approach to the project, as I will tell you further down the road. Finally, in 1870, a monolingual civil code was passed only in English this time. Of course, this recodification was a result of the end of the Civil War and the abolition of slavery. So they got rid of all the articles dealing with slavery. And we can say that nowadays, this is the code we have enforced, though after 1870 and starting 50 years ago, there has been an effort by the Louisiana Civil Law Institute to engage in piecemeal amendments. So this means that the code is amended little by little. Okay, so we will say something about the style of the Louisiana Civil Code, which if I would have to compare it with music, I would say it's more like a rhapsody. You have different tones of music. It's not only one rhythm that you can hear in the Louisiana Civil Code, and that has to do with the history of the Louisiana Civil Code. We've been just taking a look at all these layers of languages and interventions have a bearing on the style of the current style of the Louisiana Civil Code. So we will take a look at 5 things: all usages, use of Latin, the question whether or not the Louisiana Civil Code is sexist, something I call fossils, and the layout. So in connection with all usages, you can see words like arrest, for example, and I was very surprised to see this word, and I thought, well, the defendant in the action of rescission may arrest it, and I was not used to that word there, so I thought it was a mistake or a mistranslation from French, because this is an article that dates back to 1825. So I said this is an inference or false frame coming from French, and at that time when foreign, international, and comparative law librarian Seth Rostov was working at LSU, I was discussing this with him. By the way, he's been great in helping us with some of the legal history language questions we have in the project. And I shared this with him, and he told me, I think this has to do with an old usage. We're talking about the code that was written almost 200 years ago. So you have to pay attention to what arrest meant back then, instead of saying this is a false friend. And he was right. I went to the Oxford English Dictionary, and you can see there that there's a term in law known as arrest of judgment, and it means to stay the judgment or to stay the proceedings. So this was perfect English when it was written. Another, but you have to pay attention because there's a lot of that, especially in the articles that have not been amended since 1870, and sometimes they go back to 1825. So there's a lot of use of Latin in this code. I will not say it's full of Latin, but there's a lot. And we are trying to get rid of the Latin when we are translating into French or Spanish. not because we think Latin is forbidden, but because we believe in a plain language approach to this translation. We believe that as the civil code speaks also to the citizen, if we use Latin words, that may impair comprehension. And the good thing about this is that we can replace these words for equivalents in Spanish, which entail no loss of meaning at all. That's one of the key things you have to bear in mind. So the question of whether or not the Louisiana Civil Code is sexist, some articles have been published saying that it is sexist. We believe that this is not the correct approach to this, and simply the Louisiana Civil Code as a traditional civil code is part of a traditional paradigm in which the masculine was the unmarked gender, and we are conveying that in the translation. So we are following the same approach in our Spanish translation, and the same has been done in French. This is extremely interesting in the civil code. What I like to call fossils. We've seen that many provisions in the layers of years that went by since 1808, since the first civil code in Louisiana was passed. Some sections, titles were repealed, and they are still there. They are repealed. They are no longer the law, but the titles are there. So we have to deal with them. And in book one, we have these two problems, these two challenges. The first one is of master and servant, and the second one is of corporations. Both have meanings which are no longer valid in Louisiana law. The terms master and servant are no longer part of the law of the land in the state. So we had to take a historical approach. Of course, before the Civil War, master and servant was referring to slavery and free servants. After the Civil War in 1870, this was left there, the title was there, but the Civil Code then provided that there were only free servants in the state. So the word still remains, but it had a different meaning. So we took a historical approach to this. We follow what the concordances were saying, and they translated this del Señor y de los siervos, which, and we can say that the same process that happened in English can also be traced in the language of in Spanish, in legal Spanish. Siervos is a word that can both refer to slaves and to free servants. The same with corporations. So something that called my attention when I came to this state to do my LLM and study my first civil law classes was the layout of the civil code. This code did not look like what I was expecting in a civil code. When you take a look at West's edition, you see this. And in this image, you can see that you have articles, but you also have many other things like revision comments, editor's notes, cross-references. And I said, there's something weird about this. When you take a look at the traditional civil code in Spanish, what you see is this. To the left, you have the old Mexican code, and to the right, we have the Spanish civil code. You can see that in the Spanish civil code, we have some footnotes, some references, some cross-references, but it's pretty neat, it's pretty clean. You can see the articles themselves without any comments. So I discovered also that this might have to do with an influence of the common law. I believe that the fact that the layout of the Civil Code of Louisiana has all these comments has a bearing with what happens with the restatement of contracts, for example, or any restatements. This is if you take a look at the West edition of the Louisiana Civil Code, I think the layout is very similar to the restatement of contracts. So in our translation, we wanted to follow a more traditional civilian approach. So we are not translating comments, revision comments, or cross-references. We are just translating the civil code, which is the traditional approach in the civil law. And this is Professor Levasseur's pocket edition. It looks very neat, very clean. This is what we are doing in our translation. So some words about the underlying translation theory. I believe that the best way to explain what we are doing and what a good translator should do in a case like this is to take a functionalist approach to translation, that is understanding the communicative situation in which the translation is going on, and then analyzing two concepts which have been very debated, the translator's neutrality and creativity in legal translation. So The first idea of functionalism is that a translator is not a transcoder. We are not taking one language and putting it into another as if we were a machine. Creativity in translation has an important role. So when you are taking a functionalist approach to translation, you have to think of what is the most effective way of approaching this? Who am I talking to? And that decision will inform the translation strategies you decide to use. So the creator of this theory was German professor Hans Vermeer. He said that effectiveness is measured in light of function and the communicative situation. So the main takeaway from this approach is that translation is not merely a linguistic phenomenon. Translation is happening within communication. So going back to our purpose when doing this translation, who are we talking to? Well, the purpose is to make the Louisiana Civil Code available for Spanish-speaking legal scholars all over the world who have no command or poor command of English. So one of the things that functionalists discovered is that translation is not mirroring the original because there might be a change in the function of the communicative situation, what in German they call with the word Funktionsveränderung. That means a change in function. So we have an original which is the law in Louisiana. We have a translation that has to mimic that original, but has a different purpose. We are informing about the law of Louisiana. Of course, we cannot detach from the original, but we have to bear in mind that the translation strategies we choose have to be informed with our purpose of being informative about the law in Louisiana. So I will show you some examples in which you will realize that translation, legal translation, even if it's accurate and exact, is not neutral or transparent. Professor Christiane Nord from Germany added that function has to be considered together with loyalty to the reader. We have to convey a text that is accurate because we owe the reader accuracy. Other authors have also said that a good translation, the concept of loyalty is loyalty to the professional translation, and you have to do a good translation because of that. So a translation is always a specific product of its context. I'm giving you the context in which this translation is being produced, and we already discussed the other point. So a functionalist approach in this case requires accuracy, brevity, and elegant civilian style. Many opponents of functionalism have said that functionalism goes far away from the original text to do something that is not a translation, a mere recreation of the original. No, in this case, as we are translating the law, we need to be accurate. We need to be brief because we are translating a civil code, and civil codes speak to the citizen in clear and short terms, and we also have to use elegant civilian style. So one of the tenets of functionalism is also the idea of a translation brief, which is the guidelines a client gives to a translator on how that translation is going to be used and how that is going to be dealt with. So my translation brief was informed by the choices of my client, the Center of Civil Law Studies, Professor Marteau, and what he did with the French, because these projects are part of the same effort, so they have to coincide. One of the decisions we took was not to translate article titles. We are translating book and section titles, and we're using the preposition de in the titles. The amendments, the Louisiana Civil Code got rid of the equivalent in English of, but there's a combination of articles that are taking that preposition and others that are not using that preposition. And why we're doing this? Because we believe we are following traditional civilian style. Most civil codes in Spanish are written with that preposition at the beginning. We are not translating comments, as we said, because they are not the law, and we are following the French of 1825 whenever it's appropriate. So now, with the few minutes I have left, I want to give you some examples of what we are doing in 6 areas. I want to show you what we are doing with Latin, how the French is influencing our translation, what's happening with the common law influence, cases of non-equivalence, ambiguities, and errors in the original. So the first of these is the use of Latin. As we said, we are trying to get rid of the Latin, not because we do not like Latin or Roman law at all. We believe that Latin has a room, has a place in doctrine, in where communication is between experts, but in a civil code in which communication is between the state or the government or the legislature with the citizens, we prefer not to use Latin. So we are replacing all Latin words with equivalent, natural equivalents in Spanish. And you can see here that nothing is lost by changing mutatis mutandis with según corresponda. The meaning is the same. Según corresponda would be translated into English as appropriate. So I want to show you how the French is affecting the translation into Spanish for good, because I have an advantage as a Spanish translator in this case. The French translation, as I told you, is already done. And when I'm doing my translation into Spanish, I take a look at the French always. And many times, I find that what they did was good, also could be good and would be fine in Spanish, and it's improving the text. This is only one example of the many that we have. So the English says without a special provision to that effect, and I translate it literally as sin disposición especial al efecto, which is the same. But then when I went to the French, I realized that they had translated without special provision to that effect as de plein droit. And I said, this rings a bell. And I can say in Spanish, de pleno derecho, and it's better, and it's understood, and it's elegant civilian style. One of the pros, we have in Louisiana being a civil law jurisdiction or a mixed jurisdiction surrounded by a sea of common law, is that there is contamination. Common law is permeating all over the place. We have influence of the common law, and the civil code is no exception to that. In Article 778, you can see that they are using the term affirmative duties. This is, in my view, a contamination from the common law. And there's no point in having affirmative duties. If the Louisiana Law Institute were to amend this article, they should say obligations to do, which is the correct, perfect civilian English for that term. So when we are translating that into Spanish and into French, we should use natural civilian language. There's no point in saying deberes afirmativos, literally, when we can use the correct term, which is obligaciones de hacer. Same happens here in Article 27. All natural persons enjoy general legal capacity to have rights and duties. Well, we wouldn't say rights and duties in the civil law. You typically say rights and obligations. That's the pair that you will naturally see in cases like this. So we translated these duties as obligaciones, obligations. More of the common law style or terminology, contamination. When you go to Article 481, you see that they are putting terminology from the common law, adverse possessor, which what we know as prescripción adquisitiva in Spanish is also known as acquisitive prescription in English. So there is no reason to introduce common law language here. And of course, we are using prescripción adquisitiva in English, in Spanish, I'm sorry. Of course, there's a limit to the influence we can have on writing in civilian style. Sometimes we attribute to the common law style of legislation certain words or expressions, and we cannot do anything about them. We just have to translate. Our work as translators is to translate, even if we don't like what we are translating. For example, Article 1493 says that for the purposes of this article, a person is 23 years of age or younger until he attains the age of 24 years. This is a platitude. This is, of course, like this. This provision makes no sense, but it's there. We have to translate it anyway. But common law is not always unwarranted. Take a look at this. This is probably the best example in which common law has a place in the Civil Code of Louisiana. In Book 4, discussing conflict of laws, one of the most complex areas of the law in any legal system, especially in Louisiana, because it's a civil law state surrounded by common law, and the interaction with other states requires a comparative approach. This is happening here. So please take a look in English at the words barred by a statute of limitation or repose, or by a law of prescription and preemption. They are using both the common law and the civil law terminology to convey the idea of the same legal institution, the same legal concept. When you're translating this into Spanish, we don't have equivalents for the common law and the civil law, because we write in the civil law in Spanish. So we only use prescrita o caduca. This is an extremely interesting case. They are using common law in the Louisiana Civil Code, and in this case, it's justified because what in other states is called statute of limitations, in Louisiana, that is the law of prescription. So this is a good case of use of the common law in the civil code, which does not reflect in the Spanish, but that's okay. So cases on non-equivalence. There are not a lot of cases on non-equivalence in this translation, because we are translating from a civilian jurisdiction or a mixed jurisdiction with a lot of civil law into a language that expresses itself in the civil law. So most of the times there is near equivalence or full equivalence. But sometimes we find things like this, bond for deed contract. So I couldn't recognize this term as in my own system. What is a bond for deed, I said. So I translated this with an explanatory phrase. Un contrato por el que el vendedor conserva la propiedad sobre el bien hasta que el comprador pague todas las cuotas del precio. A contract whereby the seller keeps the ownership of the property until the buyer pays all the installments of the price, or all the amounts due. Which is the explanation of what a bond for deed is. But when I was discussing this with Professor Martel, we came to the conclusion that there should be a civilian term to discuss this, even if not formally equivalent to bond for deed. Of course, the image of bond for this is very clear. I give you a bond, you give me the deed, or the other way around. So the French, Professor Martel in French followed the same approach of describing what the institution or the concept in English is. But the way to solve this was very simple. Instead of spending hours doing research, I wrote to one of the validation committee members, expert in civil law contracts, and he immediately realized what we were talking about. And he told me, that's a contrato de compra-venta con pacto de reserva de dominio. He copied two other validation committee members and he said, I think that this was Andres Sanchez Herrero with the Alterini brothers. And he said, they know more of this area of the law than me, but I think this is a contrato de compra-venta con pacto de reserva de dominio. And there it was. This is something that does not happen too often in legal translation, but when you have a near equivalent, you can use it. The idea of a contrato de compra-venta con pacto de reserva de dominio is that you have a purchase and sale agreement in which the seller keeps ownership, is reserving ownership, that is. So we are also amending the French to reflect this, because they of course have this in French. So I have 3 more slides. We are about to finish. I hope you're bearing with me. Covenant marriage is a very, very interesting term too. Covenant marriage is a special type of marriage in Louisiana, the idea of which is to make it more difficult to divorce. So to dissolve the bond between the spouses. So we do not have an equivalent in Spanish for that, at least as far as we know. So we translated with an explanation, with a paraphrasing. Matrimonio con régimen de disolución calificado. That is not a legal term itself in any jurisdiction, but it reflects in legal terms what the term covenant marriage means in Louisiana. So some other examples of the problems we are stumbling upon. Ambiguities. There is a saying, which I do not accept, that whenever there's an ambiguity in the text, you have to keep it in the translation. And it's not that I say that you always have to solve ambiguities. Sometimes you have to keep the ambiguity. That is true. But some cases you cannot replicate the ambiguity in your target language. For example, the use of may not be. As we know, may not in English is a very complicated expression to use. Many authors like Brian Gardner suggest not using it at all, especially those enrolled in the plain language movement, because it can mean two things: that there's a prohibition or that you might not do something. You have the possibility of not doing something. And in this case, it's key to understand the meaning of the article in the translation. So we had to choose. It's either or in Spanish. You have to choose one of the two possible meanings of may not in Spanish, because it's not possible to replicate that ambiguity. I think we chose the correct one, which is podría no ser el padre, when the person knows that there might be a possibility that that person is not the father of the child. So we are solving the ambiguity because we cannot keep it because of the language itself. So in general, it's true that in legal translation, you have to convey ambiguities. Sometimes it's not possible, and this is one of those cases. Same happens here, may not. This is a very difficult term and should not be used in legal drafting. The thing may not demand, in this case, it's prohibition, and we translated this as no puede. And the last slide is showing you one thing, a little thing we did to improve a little bit the drafting of the original article. The last part of the article says privilege, pledge, mortgage, or security interest. This is a mistake typically incurred in legal drafting, in which the last element is actually a generic or a hypernym of the other ones that were mentioned before. So the correct translation of drafting of this in English should have been or other security interest, because a privilege, a pledge, or mortgage are types of security interests. And we are doing this in Spanish and French. We are not changing the meaning of the original. We are adding a word. So again, one of the myths of legal translation, you cannot add words. Well, sometimes to be accurate, you need to add a little something. So we are adding u otra garantía, because privilegio, prenda, hipoteca are types of garantía. So I had to run a little bit. I hope it's been interesting for you. This is the end of the presentation, and I want to tell all of you interested in this project, please write to us if you see something when we are publishing extras of the translation. We are extremely interested in feedback and in your comments. If you find a typo, a mistake, an error, wherever, we are extremely interested in that, because we want to keep improving and making this translation the best translation possible. So thank you very much for your attention today.
Thank you, Mariano. Thank you so much. At this time, I'm going to give the second code word. That word is summary. Summary is the second code word. Mariano, we did have some questions, and we do have a time for a few. So I'm going to go through what I have. The first question is, do you have any plan in the future to ever translate the comments and notes, as sometimes that is the most helpful part of understanding the code?
Well, it's certainly not part of the purpose of the translation project right now. It might be in the future. I've told you why we are not translating the comments, because we believe the normative part of the translation of the code, of the civil code, are the articles, not the revision comments. However, maybe in the future, that's something we could do. We are not doing that for now.
Okay. Second question, is there any talk of translating any key court decisions which may allow for a better explanation of the code and easier to translate as an overall story?
I'm sorry, could you repeat that again?
Sure. Is there any talk of translating any key court decisions which may allow for a better explanation of the code and easier to translate as an overall story?
We've not think of that. We haven't thought of that, of translating any decision which could inform the translation of the civil code. If I get the question correctly, maybe Professor Morato, you want to chip in?
I'll just step in. If we receive a generous donation to sponsor the project, we'll set our mind to it. Same goes with the comment.
Fair enough.
Yeah.
Fair enough.
Miriam, I just want to add that maybe one of the key jurisprudential decisions relevant for this translation project is the decision or the line of cases providing that, establishing that, that there's a prevalence for the French interpretation when there is a problem of interpretation between the French or English. So I think, top of my head, that's the first thing that comes to my mind, a very important jurisprudential decision to understand the civil code.
All right. I think we have time for a few more questions. The next one is, did you find major similarities or differences between the three legal languages?
That's extremely interesting. I think there is a common core of civilian language, which is shared by Spanish, French, and English in Louisiana, not in general common law English, but of course in Louisiana we have civilian English, and there's a lot of things we have in common. So we share a lot. So that's why I was telling that we do not have lots of cases of non-equivalence. We have lots of cases of full or near equivalence between the civil law in English and French and Spanish. And I think it's very interesting when we are doing the translation to see the enormous similarities between French and Spanish. Of course, those are very, very similar. Though we found many instances in which there are differences, and I was surprised about that. For example, I will just give you one example. The word injunction is a very difficult word to translate into Spanish. And in French, they have the word injonction. So it's very easy for them. And I thought they didn't have that word. They do. So it's great.
Okay. Another question. Did you encounter false friends in translation?
Well, there are, of course, yes, I haven't mentioned them, but there are. I cannot mention any top of my head now. Maybe Professor Morto remembers about any of the false friends they come up with in the French translation, but there are.
I sure made a true friend in the process, and I can't think of all friends off my head.
And the last two questions, where is the second code? I think maybe that's the one that was translated into French. I'm not really quite sure.
What was the question? Where?
Where is the second code?
What do they mean by where?
I think that's probably referencing the CLE code, Miriam.
Oh, shoot. Okay, sorry. Oh, well, speaking of that, I guess what I'll do real quick before the final question. The two words are limine, that's L-I-M-I-N-E, and summary, as in summary judgment.
Miriam, I'm sorry to interrupt. Going back to the last question, I now can't think of
false friends.
Yeah, I mentioned it in my presentation. Arrest, arrestar in Spanish means something different, to detain somebody, to put that person in custody. And of course, in the context of the Louisiana Civil Code, arrest, because it refers to all Louisiana law, it means to stay a proceeding, to suspend a proceeding. So that's a good one.
Okay. And the final question, how soon can we expect to see the translation online?
Well, you can access book 1 and book 4 in full already. It's there on the Louisiana Civil Code online. You can expect to consult book 2 by September or October this year. And we are planning to finish the entire project by next year. So we're moving fast.
All right. Well, I'm going to go ahead and wrap this up now. And this presentation will be recorded and will be accessible for about 30 days if you wanted to go back and see it, or if some people had thought they could make it and couldn't. So I'll be sure to get that link out to everyone. And as we close, those who you will receive a poll where you can put the code words in, and then you'll get your CLE credit. It might take a couple of days, but you will get notified of that. And again, those two code words are limine, L-I-M-I-N-E, and summary. And with that, that's all we have. Thank you so much, Mariano. Thank you so much, Professor Morito. This was wonderful, and I hope that everyone enjoyed the presentation.
Thank you very much, Miriam, and thank
Thank
you
you.
all who were there listening.
Thank you very
Thank you.
much. Bye-bye.